Welcome back to the Bar Exam Toolbox podcast. Today we are discussing a California contracts bar exam question. Your Bar Exam Toolbox hosts are Alison Monahan and Lee Burgess. That's me. We're here to demystify the bar exam experience so you can study effectively, stay sane, and hopefully pass and move on with your life. We're the co-creators of the Law School Toolbox, the Bar Exam Toolbox, and the career-related website Career Dicta. Alison also runs the Girls Guide to Law School. If you enjoy the show, please leave a review on your favorite listening app and check out our sister podcast, the Law School Toolbox podcast. If you have any questions, don't hesitate to reach out to us. You can reach us via the contact form on barexamtoolbox.com, and we'd love to hear from you. And with that, let's get started. Welcome back. Today we are walking through a contracts question. This is another in our series of podcasts talking about how to approach questions on the California bar exam. And don't forget to subscribe to our podcast so you won't miss any upcoming essay discussions. Whenever you approach a contracts question, don't forget to assess what the governing law is. Is it the Uniform Commercial Code, the UCC, or common law? In addition to analyzing what the governing law is at the outset, you should typically discuss damages at the end of your essay, even if the essay doesn't explicitly ask for it. As you'll see when we go through this essay question, we discuss potential damages even though the call of the question doesn't ask us to, and by doing so, you'll score some quick points with the bar examiners. Before we walk through today's question, we need to do a quick review of the law you need to know. So first, when a contract is for services, the common law, not the UCC, applies. A breach is a failure to perform under the terms of the contract where performance has not been discharged. A material breach of the contract allows the non-breaching party to discharge the contract. A minor, non-material breach does not. A breach is material if the non-breaching party did not receive the benefit of the bargain sought under the contract. To determine this, courts will assess a number of factors, including the amount of benefit received, adequacy of the damages, extent of part performance, hardship to breaching party, negligent or willful behavior, and likelihood of full performance. There are additional considerations for failure of timely performance when time is specified in the contract. When dates are included in a contract, including construction contracts, courts do not construe time to be of the essence unless the contract clearly states that to be the case. To provide a claim for breach, the non-breaching party must also show that he is willing and able to perform but for the breaching party's failure to perform. Anticipatory repudiation occurs when, prior to the time set for performance, a party indicates that he will not perform the obligations he agreed to under the contract. For anticipatory repudiation to occur, there must be a bilateral contract with underperformed duties on both sides. The party repudiating the contract must indicate unequivocally that he will not perform. When anticipatory repudiation occurs, it discharges the non-repudiating party's duty to perform, and that party can 1. Treat the contract as discharged, 2. Sue immediately, 3. Wait and sue on the contract date, or 4. Attempt to urge performance by the other party. Similar to anticipatory repudiation, a condition or obligation under a contract can be excused based on unwillingness to perform under the contract. This is called prospective failure of consideration. Prospective failure of consideration occurs when a party has reasonable grounds to believe that the other party will be unable or unwilling to perform when performance is due. When this happens, the other party may suspend performance and seek adequate assurances that performance will be forthcoming. Failure to provide assurances may be treated as repudiation. A modification of an existing contract must be supported by consideration. Agreements to modify a contract may still be enforced if 1. There is a change of performance, 2. A third party promises to pay, or 3. Unforeseen difficulties have arisen that excuse performance. The defense of impossibility or impracticability provides grounds to discharge a contract. In order for a defense of impracticability to be available, 3 conditions must be met. 1. An unforeseen event occurred. 2. Non-occurrence of the event was a basic assumption on which the contract was made. And 3. The party seeking discharge was not at fault. The goal of money damages is to put the injured party in the same economic position as if the contract had been performed. Damages must be proven with reasonable certainty. Expectation damages include the difference between the original contract price and the ultimate price that was paid for the work to be completed. Okay, now that we reviewed all that law, let's move on to reading the bar exam question. This is a question from the July 2016 bar exam. We will link to a webpage where you can find this question in the show notes. If you're listening at your computer, you might want to pull it up so you can read along. DIRT, a large excavating company, recently replaced all of its gas-powered equipment with more efficient diesel-powered equipment. It placed the old gas-powered equipment in storage until it could sell. On May 1st, Builder, a general contractor for a large office development, and DIRT signed a valid written contract under which DIRT agreed to perform all site preparation work for a fee of $1.5 million. DIRT estimated its total cost for the job at $1.3 million. The contract states, quote, DIRT hereby agrees to commence site work on or before June 1st and to complete all site work on or before September 1st. Because no other work could begin until completion of the site preparation, Builder was anxious to avoid delays. To ensure that DIRT would give the job top priority, the contract also states, DIRT agrees to have all of its equipment available as needed to perform this contract and shall refrain from undertaking all other jobs for the duration of the contract. On May 29th, an unusual high-pressure weather system settled over the state. As a result, on May 30th, in an effort to reduce air pollution, the state banned use of all diesel-powered equipment. On June 2nd, DIRT told Builder about the ban and stated that it had no way of knowing when it would be lifted. Builder told DIRT to switch to gas-powered equipment. DIRT replied that using its old gas-powered equipment would add $500,000 to its costs and asked Builder to pay the increased expense. Builder refused. On June 4th, seeing that no site work had begun, Builder emailed DIRT saying that their contract was terminated. On June 8th, Builder hired another excavating company which performed the work for $1.8 million. DIRT has sued Builder for terminating the contract. Builder has countersued DIRT for the $300,000 difference between the original contract price and what it paid the new contractor. So the call of the questions are, number 1, is DIRT likely to prevail in its suit? Discuss. And number 2, is Builder likely to prevail in its countersuit? Discuss. So you'll notice that with these 2 essay questions, that bar examiners leave the options for discussion wide open. But don't forget that we noted at the outset, even though the call of the question doesn't explicitly ask for it, don't forget to tell the bar examiners what law applies, the common law or the UCC, and what damages DIRT or Builder may be able to seek. So the first thing you should do is mark up your exam paper to assess what is legally significant about each fact in the fact pattern. DIRT, a large excavating company, recently replaced all of its gas-powered equipment with more efficient diesel-powered equipment, and it placed the old gas-powered equipment in storage until it could sell it. So the importance of these facts becomes more apparent as you read through the hypo. DIRT has 2 types of equipment, gas-powered and diesel-powered. If DIRT had used its gas-powered equipment, then its cost of doing the work goes up. This affects how DIRT structures its work contracts, including its contract with Builder. On May 1st, Builder, a general contractor for a large office development, and DIRT signed a valid written contract under which DIRT agreed to perform all the site preparation work for a fee of $1.5 million. With contracts questions, it's always important to note whether the contract is dealing with the UCC or common law. Here, the facts tell us that this deals with site preparation, so that's a service. The facts here also make our analysis of whether a valid written contract existed easy because they tell us it did. Make a note of the contract price. When you're dealing with contract damages, it's all about the work to be performed and the money, so make sure you circle $1.5 million. Next fact is that DIRT estimated its total cost for the job to be $1.3 million. This number is important for us determining the contract damages. DIRT agreed to pay $1.5 for the work, but the total cost of the job was only $1.3, meaning DIRT was planning on making $200,000 for this contract. Now, the facts tell us that the contract states DIRT hereby agrees to commence site work on or before June 1st and to complete all site work on or before September 1st. So whenever you see time constraints within a contract, it brings up the issue of whether time is of the essence. You'll have to use this fact in your analysis, and as you go through the rest of the facts, know whether DIRT meets these timing deadlines. Now, because no other work could begin until completion of the site preparation, Builder was anxious to avoid delays. This fact shows us that Builder's work will be delayed, so he will suffer damages if DIRT does not complete the job. To ensure that DIRT would give the job top priority, the contract also states that DIRT agrees to have all of its equipment available as needed to perform this contract and shall refrain from undertaking all other jobs for the duration of the contract. Now, to meet the obligations of the contract, Builder built in a requirement that DIRT would have to only work on its project for the entirety of the contract. So keep this in mind, because if Builder decides not to hold up its end of the bargain, it damages DIRT's bottom line. Also note the line that says, DIRT agrees to have all of its equipment available as needed to perform the contract. This could potentially include both the gas-powered and the diesel machinery. On May 29th, an unusual high-pressure weather system settled over the state. The word unusual here should bring up a red flag in your mind. Whenever we're doing a contracts analysis, remember that there are many defenses to having to perform the obligations under the contract, including the defenses of impossibility or impracticability. Now, as a result, on May 30th, in an effort to reduce air pollution, the state banned use of all diesel-powered equipment. Here again, we see another unexpected issue in DIRT's ability to perform the contract come up. DIRT has put all of its gas-powered equipment into storage in preparation for the sale, and its diesel-powered equipment has been much less expensive to use. But now, the state has banned the use of the diesel-powered equipment. So these are unforeseen issues could affect DIRT's ability to perform. On June 2nd, DIRT told Builder about the ban and stated it had no way of knowing when it would be lifted. So DIRT informed the Builder about the ban and said that they may not be able to comply with the terms of the contract. So this happened on June 2nd after work was supposed to commence. In addition, this fact shows that DIRT simply expressed a concern about being able to commence the work. DIRT doesn't make an unequivocal statement that it won't do the work. Then Builder told DIRT to switch to the gas-powered equipment. So Builder now requests a specific approach. He wants DIRT to use the gas-powered equipment. Whenever a party appears to change the contract midstream, think contract modification. This also brings us back to the original contract language that states DIRT is to have all of its equipment available as needed to perform the contract. So this raises the issue of whether it would encompass the gas-powered equipment that DIRT had already put into storage. Now, DIRT replies, saying using the old equipment would cost $500,000 and asks Builder to pay the increased expense. So DIRT and Builder are negotiating a potential modification of the contract. In exchange for DIRT using gas-powered equipment, Builder needs to pay more. But Builder doesn't want to pay more. So he refuses DIRT's proposal for the cost increase, and this directly affects whether the contract was in fact modified. Now on June 4th, seeing that no site work had begun, Builder emails DIRT saying that their contract was terminated. So prior to DIRT performing any duties under the contract, Builder decides to terminate and did so explicitly. He sent an email and said it was terminated. On June 8th, Builder hired another excavating company which performed the work for $1.8. Now, Builder, in order to get the work done, went out and hired another excavation company. The original cost for the work was $1.5, but now the other company cost an additional $300,000. When you see specific numbers like this, think damages. DIRT has sued Builder for terminating the contract. Builders countersued Dirt for $300,000 difference between the original contract price and what it paid the new contractor. So Dirt is suing Builder for breach and Builder is countersuing. So then we have these two calls of the question. One, is Dirt likely to prevail in his suit? And number two, is Builder likely to prevail in his countersuit? So remember, you've got to state the applicable law first, and then you head into the two questions. Because there are two direct questions, we should have at least two segments of our outline, Dirt versus Builder and Builder versus Dirt. Then we can further segment our paper based on the issues that come up under each of our overarching questions. For each analysis, we have 4 sub-issues that we'll discuss, so we'll go through them each separately. Number 1, Dirt versus Builder. The issue is whether a valid written contract existed between Dirt and Builder. Rule: a valid contract exists where there is an offer, acceptance, and consideration. Analysis and conclusion: a contract between Dirt and Builder exists because the facts state that Dirt and Builder formed a valid written contract. Now, when you have a straightforward issue like this, you can quickly note the issue and move on to meatier issues. You get very few points for noting this. So, issue 1B, whether Builder anticipatorily repudiated the contract by telling Dirt that he was canceling the contract before either party performed their obligations under the contract. Rule: anticipatory repudiation occurs where 1, there is a bilateral contract with underperformed duties on both sides. 2, prior to the time set for performance, a party indicates that he will not perform. And 3, the non-performing unequivocally states he will not perform. Here, Dirt and Builder have a bilateral contract with unperformed duties on both sides. The contract is bilateral because Dirt is obligated to provide site preparation work in exchange for money from Builder. Neither party is performed under the bilateral contract. Dirt hasn't done any work, and Builder hasn't paid any money. Builder then made an unequivocal statement that he was canceling the contract. Builder sent Dirt an email on June 4th stating that the contract was terminated. So our conclusion is Dirt will likely prevail on his claim that Builder anticipatorily repudiated the contract. So the next issue is whether Dirt, in order to prove his claim for breach of contract, can show that it is willing and able to perform its obligations under the contract, but for Builder's failure to perform. So to provide a claim for breach, the non-breaching party must show that it is willing and able to perform, but for the breaching party's failure to perform. So Dirt must show that it was going to comply with the terms of the contract, but Dirt wasn't able to start the contract on the agreed upon date, which was June 1st. However, the completion date was not until September 1st. Dirt could therefore argue that it was going to be able to comply with the contract terms and meet the completion deadline, and would have done so but for Builder's cancellation of the contract on June 4th. Builder will probably argue that Dirt's unwillingness to use gas-powered equipment showed that Dirt was unwilling to perform. So if Dirt could have completed the contract by the agreed-upon date, Dirt can show that it would have performed its obligations under the contract but for Builder's failure to perform. The next issue: what remedies, including money damages and equitable remedies, are available to Dirt? So the rule here is the goal of expectation damages is to put the non-breaching party in the same position it would have been had the contract been fulfilled. These damages must be proven with reasonable certainty. Builder agreed to pay Dirt $1.5 million for the site preparation work. The cost for Dirt to perform the work was $1.3 million. Thus, had the contract been performed, Dirt would have made $200,000. Dirt also declined work for this contract, and if it can prove those losses with reasonable certainty, it may be able to receive additional damages. Dirt would also have an obligation to mitigate its damages. To put Dirt in the position it would have been in had the contract been fulfilled, Builder would owe Dirt for the time Dirt didn't spend working on another contract and what it would have made during that time period if Dirt can show that amount with reasonable certainty. Now let's move on to Builder versus Dirt. So can Builder claim that Dirt repudiated the existing contract? We'd already talked about the rules, so we would just say see above. So here, Dirt asked Builder to pay Dirt the additional $300,000 it would cost them to perform the contract with their old gas-powered equipment. Because this is a modification to the contract, it must be supported by consideration to be valid. Builder, however, rejected Dirt's request and may argue that Dirt invalidly attempted to modify the contract since the contract states Dirt agrees to have all of its equipment available, but does not specify diesel equipment. Builder may also argue that they were not informed of the new ban on diesel equipment until after performance was set to begin, so that performance was already due, and that Dirt's attempt to modify constituted repudiation. However, Dirt can argue that it had not unequivocally stated that it would not perform. So our conclusion here is because Dirt's repudiation was not unequivocal, Builder should have sought reassurances before terminating the contract. The next issue is whether Dirt materially breached the contract by failing to start work on June 1st. Determining the materiality of a breach will look for multiple factors, including the amount of benefit received, adequacy of damages, extent of part performance, hardship to a breaching party, negligent or willful behavior, and likelihood of full performance. When dates are included in a contract, including construction contracts, courts do not construe time to be of the essence unless the contract clearly states that to be the case. So here, the contract specified that Dirt would begin work on June 1st, and Dirt failed to do so. Dirt had gas-powered equipment available to do the job, even if it was in storage, but chose not to use that equipment due to the increased cost, despite the contract requirement to have all equipment available to do the job. Builder will argue that since it was not even informed about the ban on diesel equipment until June 2nd, nor is there any evidence that they were aware that Dirt had recently replaced their gas-powered equipment with more efficient diesel equipment prior to entering the contract, that performance was due on June 1st, and therefore Dirt breached when they hadn't started as of a June 1st. Dirt will contend that time was not of the essence because the contract didn't explicitly state that the start date was an imperative. Although Builder could not complete the project until Dirt concluded its work, that work wasn't due until September 1st, regardless of when Dirt started. So in conclusion, because the contract did not state that the June 1st start date was essential, nor did Dirt state that it would not complete the work by September 1st, a court would likely not find Dirt's breach material. Our next issue is whether Dirt can claim that impossibility or impracticability discharged its duty to perform and thus it did not breach the contract. So contract obligations are discharged where it has become impossible to discharge them, such as destruction of the subject of the contract. A contractual duty may also be discharged where performance has become extremely and unreasonably difficult, and this difficulty was not anticipated. In order for a defense of impracticability to be available, 3 conditions must be met. 1, an unforeseen event occurred. 2, non-occurrence of the event was a basic assumption on which the contract was made. And 3, the party seeking discharge is not at fault. So the analysis here is that it is not impossible, just more costly for Dirt to perform. So an impossibility argument will fail. Dirt has a better argument for impracticability. The unusual weather system and the state ban were not anticipated by the parties, and the increased expense is substantial. If the increase of $500,000 or 30% of a $1.5 million contract is found to be subjectively extreme and outrageous, then Dirt may have a basis to discharge his obligation under the contract. Further, the contract is no longer profitable for D since they were only making $200,000 in profit. Facts say that D estimated its cost to be $1.3 million using their new, more efficient equipment. So Dirt will likely succeed on its argument that its duty to perform is discharged on the grounds of impracticability because of the unforeseen weather system, the state's following unforeseen diesel ban, and the high cost of implications for Dirt. Note that if Dirt claims that his duty is discharged by impracticability, then he cannot sue Builder for breach. All right, our last issue. If Builder prevails, what damages would he be entitled to? Monetary damages seek to put the non-breaching party in the position they would have been in had the breach not occurred. So here, expectation damages are the difference between the contract price with D, which is $1.5 million, and the contract price of $1.8 million, or $300,000. In terms of consequential and incidental damages, the facts don't give any information regarding the consequential or incidental damages. But if Builder incurred additional expenses in finding another excavating company, they would be entitled to these incidental damages. And if for some reason the new company was unable to complete work by September 1st and caused any losses, these could be recovered as consequential damages as well. All right, that's it. Now with essays with more open-ended questions like you see here, which often happens in contracts, creating a strong outline at the outset will help you streamline your response and ensure that you hit all the issues. And with that, we are out of time. I want to take a second to remind you to check out our blog at barexamtoolbox.com, which is full of helpful tips to help you prepare and stay sane as you study for the bar exam. You can also find information on our website about our courses, tools, and one-on-one tutoring programs to support you as you study for the UBE or California Bar Exam. If you enjoyed this episode of the Bar Exam Toolbox podcast, please take a second to leave a review and rating on your favorite listening app. We'd really appreciate it, and be sure to subscribe so you don't miss anything. If you are still in law school, you might also like to check out our popular Law School Toolbox podcast as well. If you have any questions or comments, please don't hesitate to reach out to Lee and Alison at lee@barexamtoolbox.com or allison@barexamtoolbox.com, or you can always contact us via our website contact form at lawschooltoolbox.com. Thanks for listening, and we'll talk soon.